Hello and welcome to The Buck Stops Here. Two big stories being tracked by us today, two big discussions as well. First of all, the entire question in the corrupt judge case, or the alleged corrupt judge case. Did the former Prime Minister Manmohan Singh intervene in some way, and did the Chief Justice of India finally take action to allow him to continue, in a sense, under pressure from the then Prime Minister? That's question number one. And we're also taking a look at the other really big question that you should be asking yourself as a parent. Is your child safe in school? Not just because of the recent cases of rape or that brutal video we've been seeing about children being beaten up, because studies are showing a very large number of children in India are actually facing abuse, many of them in school. So we'll be taking a close look at both of these very big subjects of discussion for us. But I'm just going to start off by taking a look at the latest reports coming in on apparent intervention by former Prime Minister Manmohan Singh's office. Rahul Srivastava joins us for more on that. Rahul, a note apparently written by the then Prime Minister Manmohan Singh, that's what the Chief Justice apparently acted on.
Vikram, that's how the controversy started. There were charges that there was political and executive interference as far as the appointment or confirmation of a judge who was facing serious charges as far as integrity is concerned. Now we have details that the Prime Minister's office wrote a note backing the judge, despite the fact that the Supreme Court Collegium, which is responsible for the transfer, appointment and confirmation of judges, had serious reservations about it. The Supreme Court Collegium was clear that there are serious charges against him and there should not be any confirmation as a permanent judge. This letter written by the Prime Minister's office in May 2005 clearly indicated that the Prime Minister's office did intervene. But the story does not stop here, Vikram. The story goes on because the Collegium was very firm. The Collegium wrote back again to the government that there are serious concerns and serious charges, and that is why there should be a reconsideration. But then the Law Ministry wrote back again, backing the judge. And then comes the most important element in this, when the Chief Justice of India noted down on the file that an extension is being given, not a confirmation as a permanent judge, given the sensitivity of the government on the issue. Sensitivity of the government on the issue, perhaps the most clinching element in this entire story. Now the backdrop is that H.R. Bhardwaj, the then Law Minister, had told us yesterday that 16 to 18 members of Parliament had met the Prime Minister backing the judge, saying that grave injustice was being done to him when he was being denied a confirmation as a permanent judge. And it is acting on that. Eventually, the Prime Minister's office wrote the note. The Law Minister backed it, despite the Collegium saying twice that there should be no confirmation. That's what perhaps confirms that the executive actively interfered as far as the appointment of a judge who had slightly not so credible past.
All right, Rahul, thanks for joining us for that update. And obviously, the situation continues to be something that needs to be resolved, because as we were just seeing, discussions and debates and tussles between the executive and the judiciary, especially on the question of the appointment of judges, continues even till now. And there's a face-off happening even as late back as June. Well, H.R. Bhardwaj did speak to us on that issue yesterday, but I did speak to him just a short while back and again asked him on the latest after the fresh revelations that have just been made about possible interference directly from the Prime Minister's office. Here's what he said to me. Mr. Bhardwaj, thank you so much for joining us. Now, when you were talking to NDTV just a day or two ago, you said that you'd spoken to the Chief Justice on this entire issue, but eventually it was his decision. It now turns out that the Prime Minister had actually written a note on the 17th of May 2005, and it was only after that that the Chief Justice did anything.
Let me tell you, this was a consultation process from the High Court, CJ, and then my office, and several representations coming from the various quarters. So they are all available on the file, and responsibility was entirely mine to see that full consultation process is done with the CGI, and ultimately the authority to recommend or not recommend, it lies and vests with the Chief Justice of India, and thereafter it was my turn to recommend it to higher ups. So this is a stage which was absolutely dealt with by me with the CJI and various stages of consultation process.
Right.
The
But
CJI
Mr. Bhardwaj, if I could just
extended his tenure.
So, Mr. Bhardwaj, if I could just try and understand this. See, you seem to be saying earlier, and that was the indication, that it was the Chief Justice's decision. It now turns out that it was the Prime Minister who wrote to him on the 17th of May, and after that, the notings of the Chief Justice on the file pretty much say, in view of the sensitivity of the government on this matter. So that in a sense shifts the responsibility squarely on the UPA government and specifically on the Prime Minister himself.
No, absolutely misunderstood. There is a procedure that the Law Minister, who is head of the Law Ministry, independently on administrative side consults the Chief Justice of India and other consultees, like the Chief Justice of State and other functionaries, and whatever papers come, they are ultimately submitted to the CJI, and his view are again gone into by the Law Minister, and thereafter his conclusions are submitted to the Prime Minister and to the President. This is the whole consultation process, which is very comprehensive.
No, that's
Prime Minister comes after.
It's fine,
Prime
sir,
Minister comes after the Law Minister.
I get that, but what seems to be coming across is the situation where the Collegium is insisting repeatedly that the judge should not be confirmed. The Collegium saying that there are allegations against him, and it then seems to be coming that there is direct pressure from the Prime Minister himself on the 17th of May. And this is coming after a political party says we're going to withdraw support if we don't do something about this. So it comes across more as a case of the Prime Minister, then Prime Minister, leaning specifically on the Chief Justice of India. And the Chief Justice pretty much saying this, the government is sensitive on this, which is why I've gone ahead.
Absolutely incorrect. Prime Minister does not come unless I submit the file to the Prime Minister. Individually, as a coalition head of the government, there may be various topics which he discusses with his allies, but in judicial appointments, his role would come when I recommend to him. He may receive representation, all this, they are all forwarded to our ministry and they are always kept on record. And in this particular case also, all representation received for or against, they are on record, and ultimately I was the person who had to obtain complete consultation process completed. So then finally I took a decision. Prime Minister is head of the government. He deals with his allies in his own way. And I personally think in this particular case, I dealt with the matter.
No, I'm sure you dealt with the matter, and I'll ask you therefore whether you were in agreement with whatever happened. But I'm just asking you specifically, you're right, it's a matter of the record. Did the Prime Minister send that note on the 17th of May 2005 or did he not? And did the Chief Justice of India say on the file, I am doing this because of the sensitivity of the government? What's the truth in both those cases? Did the Prime Minister send the letter or no?
Let me tell you, Prime Minister never sent me a note. Some papers were received from the MPs, other representatives. But if there is any note from Prime Minister, it must be on the file. He never one-to-one said me that this has to be done, that has to be done.
So you're not confirming, you're saying that there could have been a note from the Prime Minister which could be on the file. You're not confirming or denying whether he sent the note.
No. How can I? It is 12 years or 10 years ago. Papers came in all cases. Whatever process is done, consultation remains on the file, and the entire consultation is placed before CJI. And then he applies, whatever he records is his note, not my note. My note must also be on the file. So you can look into all this. There is nothing unusual in this case. It is unnecessary. So much of mountain is being made of a molehill, and there was no problem.
But I'll tell you why it's
I don't know what
if there is a mountain, if there is what you're calling a mountain on a molehill, it's for one reason, which you're not actually directly contradicting one way or the other. It seems to be that judicial independence, judicial independence is one of the benchmarks of the way of the Indian system of government, and based on the Constitution.
And you think the Katju is the person? No. Do you think the Katju is the person upholder of judicial independence, not the Prime Minister or Chief Justice of India?
No. Let's set Mr. Katju aside.
They are more responsible.
I'm sure they are. I'm just setting Mr. Katju aside for the minute. I'm just trying to understand from you as the Law Minister at that time. Was this a case where the government intervened and said, we are having problems with our coalition partners, therefore we have to intervene in judicial appointments? That's the bigger question. Let's set Mr. Katju aside. Did the government intervene or no?
The sensitivity of the matter is, here was an additional judge from the scheduled caste community who was making allegations that I am being discriminated against because I am a weaker section man. And then his own people in Tamil Nadu represented it. And thereafter, the Chief Justice of India was informed by me, not by Prime Minister. If there is anything on record, it is definitely on the file. And I sent the papers to CJI, writing in my own hand, that is the basis on which CJI extended his tenure. He did not confirm him, and then ordered a regular probe into the whole episode. And then it took about a year to do all this. How could if Prime Minister had influence, it would have been done instantaneously. Prime Minister never interfered. Of course, on political side, many people meet Prime Minister, I don't know. But in this particular, falsely, Prime Minister is being dragged into it. The boot is on the other leg.
All right. So one final question. If you recall the case, was it or was it not correct that the Chief Justice then wrote on the file, I'm doing this in light of the sensitivity of the government on this matter? Was that correct? Because again, that smacks then of he did it because there was political pressure.
I agree. No.
Was that noting on the file or no? I'm sure you remember that.
I can remember one thing. I have dealt with thousands of cases during last 15 years.
Right.
There are many such cases where the Chief Justice of the High Court does not recommend a man, and that the aggrieved party judge represents to CJI and redressal of grievances done after full inquiry. I can quote cases after cases where the Chief Justices do not recommend people or recommend people, and finally the authority is Chief Justice of India. And in confirmation of Supreme Court judges, of the High Court judges, only CJI is the factor which determines. No collegium is consulted. It is at the initial stage of appointment. When judges are appointed, collegium is consulted, but in their confirmation from additional judge to the permanent judges, only CJI. And I do remember the sensitivity of this case was, he was a member of scheduled caste community, and several allegations were leveled against Katju himself. And then he got out of that court case, from that court to other court. And he knows all this.
All right, Mr. Bhardwaj, thank you so much for speaking to us. Thank you. All right, we are going to hear a little bit more about that in just a couple of minutes. Harish Salve is going to be joining us. Prashant Bhushan is also going to be joining us. But I do want to very quickly, gentlemen, if you will just stay on with me for just 2-3 minutes. There's another big story that is coming in that we are breaking right now, actually. Mr. Vaidyanathan has got this NDTV exclusive, an opinion coming in from Mukul Rohatgi, the Attorney General of India, on the case and the possible charge sheet against Samarans. Mr. Vaidyanathan, just tell us all the details you have on this.
In fact, Attorney General Mr. Mukul Rohatgi has given his opinion to the CBI Director. According to our sources, he basically said that charge sheet can be filed against Marans, both the Marans, Kalanidhi and Dayanidhi. The issue came to Attorney General because there was a difference of opinion between the Director of Prosecution and the CBI Director, whether to file charge sheet or not. Director of Prosecution opined saying that there is enough evidence, we can file charge sheet. But CBI Director said there is no enough prosecutable evidence, it won't stand in the court, so we can't go ahead. So as per procedure, it was referred to Attorney General earlier in the UPA government, but Mr. Vahanwadi, then Attorney General, was unwell, so it was kept pending. Now when the new government took over, it was sent to Mr. Mukul Rohatgi, the new Attorney General. According to sources, he has given his opinion today to the CBI Director, basically saying that he agreed with the CBI Director of Prosecution, saying that there is enough evidence and circumstances, so go ahead and file charge sheet. So now CBI will no other option to go and file charge sheet. In fact, when the case was taken up in the 2G scam in the Supreme Court, CBI repeatedly told court saying that the Malaysian government is not agreeing and giving enough information. The charge by the CBI is that Shiva Shankaran, who owned Aircel, was forced to sell it to a Malaysian-based company, that company which later invested in Sun Network. So this is a charge, and CBI found it there is a quid pro quo and which was favoring Dayanidhi Maran. So now CBI director will have to go by AG's opinion and file charge sheet.
All right, so that's important breaking news coming in from you right now, Mr. Vedant. Thank you so much for joining us with that. So essentially, Attorney General Mukul Rohatgi agreeing with what the Director of Prosecution had actually said, and therefore is asking the CBI to go ahead and file that charge sheet. So we'll obviously have more on that story as fresh developments come in on that. But I just want to return now to this entire corrupt judge matter. Prashant Bhushan with us, Mr. Harish Salve is with us as well. You were both hearing what Mr. Bhardwaj essentially was saying right now. He says, look, there's no interference, nothing wrong has actually been done. I just want to get your take on these latest, Mr. Salve, why don't I start with you, the fresh revelations that in a sense there was pressure coming in from the Prime Minister's office. Whatever spin Mr. Bhardwaj might be putting on this, that I did it, not the Prime Minister, there was political pressure because there was an ally of the UPA which wanted something done. So pressure was put on a judicial appointment. Is that not something which is wrong?
Vikram, my primary concern as a lawyer and as a citizen is, well, when this 1991 judgment and followed up in 1993, when these cases came up, the primary ground on which we supported wresting the power from the executive and construing the constitution to put it within the court and within a collegium was that it would be insulated from these political winds, whether they came from Mr. Bhardwaj or whether they came from the Prime Minister or from anybody. Now, if and secondly, and I don't know whether this has come on your channel on record, Shanti Bhushan ji had filed a writ petition challenging the appointment of this judge, Justice Ashok Kumar, and in that there was although the Supreme Court dismissed the petition saying we can't turn the clock back, there was a criticism of the manner in which repeated extensions were granted to this judge, at times without consulting the collegium, and there is some suggestion that it was done because of these reasons. Now, possibly the judges sent for the file and saw the file. Now, I don't want to get into a political battle about who recommended and who did not recommend. The fact of the matter is there was something seriously deficient in the institution. And I read on your blog, on your channel blog on the iPhone, that even Mr. Fali Nariman has said, much as Mr. Katju seems to be now virtually in a spat with a former Chief Justice, which is most unseemly. The point which he has raised, the allegation which he has raised, raises serious issues about the appointment process, and that's what we need to focus upon and debate.
Right. So, of course, yes, we have had today both Soli Sarabji and Fali Nariman coming out and saying, look, the overall issue needs to be looked at, but they both have, in a sense, questioned the way Mr. Katju himself has done this. Harish Salve, do you agree with those reservations as to the way this has been done right now by Mr. Katju, the fact it's happened so many years later, motives are being ascribed?
I saw him, absolutely, see, I saw him on your channel. He had no satisfactory explanation of why he kept quiet for 9 years. He is very much a part of the system. He didn't protest at the time as Chief Justice. He didn't protest when he was brought to Supreme Court and so on. So that criticism is something which he has to answer. And he, I'm afraid, not answering. I believe he walked off your channel interview. He was more patient with the other channels.
He's
but
supposed
he kept,
to be coming back right now, but as you can see, I don't see any signs of him. So maybe he's walked out of this interview.
He is not, up till now, I have not heard an answer. Second, he has said what he had to say. I believe he has now leveled 6 specific allegations against Chief Justice Lahoti and stuff like that. Now this is, I don't at all agree with the manner in which he is going about it. But the allegations which he has made are extremely serious. Whether he should have kept quiet for 9 years is the question. The question is not why he brought them out. The question is why he brought them out so late. But having brought them out, we can't now brush them under the carpet, especially after all the revelations which have come out and considering that this was taken in judicial review and there is a judgment of the Supreme Court which does suggest that there is something in what he is saying. So where did the appointment process go wrong? Okay. Where has this been going wrong? We need to check, and we need to consider and whether this system should be allowed to continue or be substituted by an appropriate mechanism like a Judicial Appointments Committee.
Okay, so Prashant Bhushan, let me first ask you the specifics of this particular case, which clearly are getting murkier by the day. Political intervention, whether it was Mr. Bhardwaj who took the decision or the Prime Minister who took the decision or whoever was to blame, clearly there was some sort of political influence that played itself out in this case. So your take on this case specifically, and then I want to come to the broader question of how we can ensure that it stops now. There should be a very clear-cut system by which judges are appointed, which is not subject to political pressure.
No, my take on this case is very clear. The facts as stated by Justice Katju appear to be totally borne out, not only by the Supreme Court's judgment in that case regarding Justice Ashok Kumar, which was filed by Mr. Shanti Bhushan and Kamini Jaiswal, but also by what Mr. Bhardwaj has disclosed and these notes etc. that have come out. It's absolutely clear that though there were serious allegations against this judge, though his confidential reports as a district judge were very, very bad, though the then Chief Justice believed that this judge was not fit to be appointed a judge, yet despite all that, in the light of the political pressure mounted by the then UPA government, whether that pressure came through Mr. Bhardwaj or through the Prime Minister is not very important, but because of that pressure, the then Chief Justice, not just the then Chief Justice, but the subsequent Chief Justice and the subsequent Chief Justice, they all succumbed, and eventually this gentleman was given first one extension of 1 year, right, then another extension of 6 months by the next Chief Justice, and then he was eventually confirmed by Chief Justice
you are saying there was clearly a process of pressure that was put in this particular case. That seems to be coming across.
There is no doubt about it. There is no doubt about it. The facts leave absolutely not a shred of doubt about it, and the facts are also absolutely clear that this judge's reputation was very bad, and the Chief Justices and the Collegium knew that his reputation was very bad, and he was not fit to be appointed.
I am wary about, a lot of time has passed, people are not here anymore, so therefore we should also be a little careful about judging former judge too much right now. I want to actually move it forward. I want to move it forward a little bit. Harish Salve, how can this be fixed? Because at the end of the day, you could always have a situation where the Prime Minister writes or somebody else writes, the Law Minister says this is something important. How can you fix judicial appointments, doing it properly?
Let me answer straight away.
In a manner that you don't have any
Let me answer straight away.
Yeah.
First of all, you're right. We should not be casting aspersion on the reputation of any person, least of all someone who's not here on earth to defend himself. That is why saying, was there material before the court which suggested that he was not fit to be a judge? That obviously is so. Now, whether it is an IB report, Mr. Sorabji's criticism saying don't believe IB reports, but then for others you have believed IB reports. That is not the point. The point is you have a process. You follow the IB. Now, I can understand a Chief Justice saying, I reject this IB report, it is a nonsense, and I make him a permanent judge, but that's not what happened. So, we are not on his reputation, we are on an institutional failure. Which brings me to answering your question. We now need an open, transparent system in which names are received by a multidisciplinary body. There should be people from the judiciary, there have to be people from the political executive, and there have to be some people from either from civil society or lawyers or eminent citizens. I'm sure you can find 5 or 7 eminent Indians. These appointments with such huge constitutional powers, appointments to High Court, appointments to Supreme Court, should be by a properly constituted commission and in a manner where it is beyond political pressure.
All right, Prashant, your specific suggestions on this. How do we crack this once and for all?
See, firstly, we need a full-time body to make these appointments to the High Courts and the Supreme Court. More than 100 judges are appointed every year to the High Courts and the Supreme Court. And to select these 100 judges out of thousands of possible applicants or thousands of possible nominees, you would require a full-time body which can first lay down a criteria for selection and then compare the various nominees or applicants on the basis of that criteria and then select the best. This job cannot be done by an ex officio body of sitting judges and the law minister, etc. It can only be done by a full-time body. So this Judicial Appointments Commission, which has been suggested by the government, is an ex officio body of 3 sitting judges, 1 law minister and 1 jurist appointed by the government. This is not the right body. This body can select a full-time body which will be independent of the government as well as of the judiciary, which will be tasked with selecting these judges in a transparent manner. And that minimal transparency that is required for this is that before you finally select the people, put the shortlisted candidates on a public website so that members of the public who have some information about them can share that information with the selecting authority. If that procedure of that transparency had been there in Ashok Kumar's case, then I am sure that his appointment would not have gone through.
All right, I'm afraid we're going to have to leave it there for the moment. We will continue to look for actual specific suggestions and solutions as we go forward and how this matter can actually be sorted out so we don't have another case like this again. Prashant Bhushan, Harish Salve, thank you both so much for joining us.